for our last case, which is 126705, State versus Tristen Jeffrey Rogers from Butler County. Council, could please come forward and announce your appearances.
May it please the court, Honor David Miller for Tristen Rogers.
May it please the court, Jared Regier on behalf of the state of Kansas.
Good afternoon, Your Honors. I would request of the court 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. I wanted to start the argument off here today on issue 2, which I raised in my brief, and that is the argument that as applied, the Kansas Sexual Offender Registration Act is unconstitutional as applied to Mr. Rogers. And I wanted to quote, it's a short quote, but it's Record, Volume 5, page 26, and it's testimony from Ms. Unruh Revel, who actually is treating Mr. Rogers in sex offender treatment. When I asked her, what's your opinion about Mr. Rogers having to register as a sex offender, she said, quote, "I don't see the gain from that for the community or for him. I don't fear for the community, and I don't see him as someone that's a danger," end quote. The argument that was raised below and then is raised here before this court, I've argued that the statute's unconstitutional under what is called an irrebuttable presumption doctrine or framework. And I may not have been as clear as I probably should have been in the brief, but in preparing for argument, the irrebuttable presumption framework or doctrine is actually a substantive due process. It's a species of substantive due process. And I would just cite the court, Michael H. versus Gerald D. It's a plurality opinion from the United States Supreme Court. It's 491 U.S. 110.
Counsel, why,
Yes.
what I'm having trouble wrapping my head around with respect to this issue is why isn't the mandatory registration requirement for certain offenses a rule of law rather than an irrebuttable presumption? The Larson case seems pretty persuasive to me in how it kind of draws, there's an analogy there with the DUI statute. Help me kind of deal with that concept.
So I think whether you want to call it an irrebuttable presumption, whether you want to call it a conclusive presumption, as I think is discussed in the Larson case, or whether you call it a substantive rule of law, however it's framed, I don't think really matters in the sense of, and if you look at the cases like Michael H. versus Gerald D. that I cited to the court there is saying the irrebuttable presumption doctrine or the substantive rule of law doctrine, the due process clause and a substantive due process challenge goes to whether that substantive rule of law or the connection between the policy underlying the substantive rule of law, is there a connection between that and what the law's end is? And so, again, whether it's, however you classify it, whether it's a substantive rule of law or not, the substantive due process irrebuttable presumption framework, I think, goes to that issue. One, what is the underlying policy of the substantive policy of the sex offender registration statute? And as Wilkerson says, the legislative purpose is, and rationale is, the legislature wants to protect citizens from sex offenders. And the underlying rationale for that is that as a class, sex offenders, and I believe the phrase that has been quoted many times is the recidivism rate is frighteningly high. So that's the presumption, that's the substantive rule of law, or the policy that the substantive rule of law is based on. And under the irrebuttable presumption framework, my argument is that presumption, is that rule of law, or the policy underlying the rule of law, is that universally or even necessarily true? In an as-applied challenge, the answer to that question, with regard to Mr. Rogers, is no.
Well, and the other thing I'm struggling with in this case is the way I'm reading the evidence on the potential for recidivism, potential for reoffending, whatever you want to call it, is, well, the likelihood of reoffending is low if this defendant engages in counseling and continues to do all the things he's been doing before sentencing, which I understand a defendant, you know, in order to try to put on a good face before sentencing, we're going to try to do as much as possible. But without these requirements after sentencing, there is no requirement that the defendant continue to do those things that the doctors are saying are required in order to keep, you know, his risk low. So isn't that the point of why we have, you know, the registration and the supervision, is because we need these checks in order to keep the defendant doing those things?
Well, Mr. Rogers, he's on probation, and I don't want to, I didn't read the probation order before I came here, so I don't want to misquote the record, but my memory of being at sentencing hearing is the judge essentially ordered as conditions of probation that he continue to follow the recommendations, to follow sex offender treatment.
But only as long as probation continued.
Correct, which is 36 months.
Okay, so then after that, then we have no certainty that he's going to continue to do that. And isn't that what the doctor said is important in order to keep his risk for reoffending low, is that he continue with all of those treatment? I mean, isn't that the point of having the lifetime supervision, is so that they continue to do the things that keep the recidivism rate low?
Well, so lifetime supervision or a registration, I'm sorry, is it?
Lifetime supervision.
Okay. I'm sorry, my argument was on the registration part, I'm sorry. So
No, and I was jumping around, so I may have confused you. You were talking about the low rate of recidivism. You were
Yes.
quoting those things, and so then it triggered, you know, my question with respect to the other issue in the case. So I apologize for getting you off track.
No, that's fine. As far as the lifetime or the mandatory lifetime post-release supervision is concerned, again, I wanted to submit that kind of on the briefs, but it's.
Right, because we're kind of stuck with, was it in-rate NR
Yeah.
on that one? And I respect that your candid argument there.
Yeah, and I think with NR and with Wilkerson both, and again, I may not have laid this out as clear as I should have in the brief, but those are procedural due process arguments. And I think the presumption, or the irrebuttable presumption, or conclusive presumption, or whatever you want to call it, is a substantive due process, which is different. It's a different analysis. And that's why recognizing NR, recognizing Wilkerson, I think the court's not necessarily bound by those decisions, because this is, as I argued in my brief, a different due process framework. I don't know if
I appreciate you making that distinction.
and it's important too, because when NR, it's holding, basically saying he got all the process he was due during when he was convicted. They cite to Department of Public Safety versus Doe, which is a U.S. Supreme Court case 123 Supreme Court 1160. That's what they're relying on. And if you look at Doe, towards the end of the opinion, Doe also says the petitioner in that case was raising only a due process, or a procedural due process argument, and then, quote, this is 538 U.S. at 8, Such claims must ultimately be analyzed in terms of substantive, not procedural due process. So that's my argument, is the argument that I'm raising here is a substantive due process argument. Under the irrebuttable presumption framework, again, and I see I'm running out of time here, but the record below, I think, demonstrates the very low risk, specifically with regard to Mr. Rogers and his recidivism rate or chance of reoffending, which was really not rebutted by the state below. They never called any expert witnesses. And then, finally, does the state have a procedure or alternative procedure in place that would address the issue? And the argument is yes. All the tests that Dr. Goodman performed, all the tests that Ms. Unruh performed as well, in addition to these sort of risk assessments are done under the sexual offender or the violent sexual offender law all the time. Those kinds of risk assessments are done. So there is something in place that would address that issue. I know I've run out of time. I did raise a Section 1 argument as well, and relied on Hode's, that is the decision from the Kansas Supreme Court, which again analyzed Section 1 under a strict scrutiny analysis. And under strict scrutiny, again, we would argue these are fundamental rights that are being implicated here. And then the state, under strict scrutiny, has to come forward with a compelling state interest that is the least restrictive means. We cited some out-of-state cases for persuasive authority from Alaska, from Massachusetts, from Hawaii. They interpreted their state constitutions holding the strict scrutiny applied specifically in the sex offender registration context, and they said the state had presented a compelling state interest protecting the public, but that it wasn't narrowly tailored because there was a broad sweep of all sex offenders are high risk of recidivism. And we put on the evidence below that's not the case generally, and specifically with regard to Mr. Rogers, that is not true. I see I've run out of time, and I would submit issue 1 on the brief and would ask that this court respectfully reverse the decision of the district court and discharge Mr. Rogers both from the duty to register as a sex offender and also find as applied the lifetime post-release supervision is unconstitutional.
Thank you, Mr. Miller. You'll have 4 minutes rebuttal.
Thank you.
Mr. McGeary?
Your Honors, may it please the court. Your Honors, ultimately this is an appeal about a defendant's attempt to circumvent a lawful statutory scheme that has been held constitutional multiple times by the appellate courts of Kansas. With respect to both issues, really, as a preliminary, the statutes are presumed constitutional, and all doubts must be resolved in favor of their validity. In the Seward opinion issued by the Kansas Supreme Court in 2013, when the Seward Court considered case-specific disproportionality challenges to Jessica's Law, in which lifetime post-release supervision was imposed, the Seward Court mandated that if there's any way to reasonably construe a statute as constitutionally valid, the court has both the authority and the duty to do so. Now let's say that this court does find that the defendant's speculations about what might happen to him in the event he is unsuccessful on probation, at least insofar as the lifetime post-release is concerned, if that is even before this court, our appellate courts have used the Freeman factors repeatedly for analyzing supposedly unconstitutional sentences, both under Kansas Bill of Rights Section 9 and Eighth Amendment claims. Now in this matter, the district court specifically identified in its written ruling several risk factors that of the defendant before denying the defendant's motion to find that lifetime post-release supervision was unconstitutional as applied to him. With the first factor, the district court specifically identified the defendant's alcohol use, the defendant's moderate risk, the number of images retrieved by law enforcement, I believe it was approximately 2,000.
Now, counsel, I did have a question about that. So the district court was talking about the number of images, but I mean, the total number of images, the 2,000, those weren't all illegal, right? Wasn't it just 10 or 12 out of the 2,000 that turned out to be illegal?
The state's understanding is that of these 2,000 images, there were several files containing suspected child pornography, and before the guilty plea was entered in this case, the state had charged with the defendant with 11 counts of child pornography, specifically sexual exploitation of a child.
So 11 out of the 2,000.
That would be the state's understanding.
And were those still images or were those videos?
The video footage is from what I understand.
And was there evidence, I mean, was there any evidence that the defendant had any awareness that those images were in this large download?
The state's understanding is when the defendant was interviewed by law enforcement, he admitted to possessing the images, that he was considering selling these child pornography, and that it gave him a thrill to view these images.
No, my question goes back to before he knows they're there, before he's seen them, did he know they were going to be there when he downloaded the large file of 2,000 images?
That is the state's understanding of the testimony.
That he knew there was some child pornography in there?
Yes.
And what is the basis for that position?
When the defendant was interviewed by law enforcement, he admitted to it. To knowing that the images in the Dropbox account, the files in the Dropbox account contained child pornography.
But when he placed them in the Dropbox, was he aware he was placing child pornography in the Dropbox?
To the best of my knowledge, yes.
Okay. My question has just left my mind, I'm sorry. Proceed, I don't remember what I was going to ask.
Again, besides the moderate risk of the number of images with respect to the first Freeman factor, the district court also identified, again, the thrill the defendant received from viewing the pornography and how the defendant considered selling the pornography at one point. With respect to the second...
Was there a distinction between the legal pornography and the illegal pornography with respect to potentially selling it or the thrill?
Not to my knowledge.
So everything, and I'm sorry, I keep interrupting you. The thousands of images that he downloaded, was that all pornographic and then just a portion was child pornography, or was that innocuous and these just happened to be embedded?
That I cannot say for certain.
Okay. So my next question is on the pornography giving the thrill and the selling it, that was specific to this child pornography, not just he generally finds pornography thrilling and he generally was going to sell it. It had to do with these specific videos.
I cannot speak to these specific images, but the district court did note that as a general matter, those were additional risk factors that the court specifically identified with respect to its written ruling on the first Freeman.
So it was to child pornography, not pornography, just generally speaking.
As far as I'm aware.
Thank you.
With the second Freeman factor, the district court did specifically note how child pornography convictions are treated as less severe than other felony convictions in Kansas. As far as the third, again, looking at this exact same offense, and the case law is pretty clear, it has to be the same offense for other jurisdictions. The district court found that no information was presented by the defendant in that issue when it made its ruling. Apparently, the defendant hopes by raising this appeal to invalidate the entire state of Kansas felony sentencing scheme by claiming that lifetime post-release supervision constitutes cruel and unusual punishment under Section 9 and the 8th Amendment and cannot survive constitutional muster, even though we have countless cases not only affirming lifetime post-release for this type of conviction, but for other convictions as well.
Do you have any cases that you could cite where the defendant was only convicted of possession of child pornography that had no criminal history and no other crimes, where they challenged the imposition of lifetime post-release supervision and it was found constitutional as applied?
For Forgive me if I may review my notes briefly. Not off the top of my head as far as child pornography specifically, but the State v. Hardy decision, which the state references in its brief, is illustrative of that point. In that case, the appellant was convicted of one count of indecent liberties with a child and one count of lewd and lascivious conduct, and the court did specifically note in the opinion the then appellant's arguments that he had no prior sex offenses, that he was under the influence of alcohol when those occurred, and they also addressed the recurring use of the Proctor decisions, which I addressed in my brief as well. They found that did not provide a basis for relief because at the time that the Proctor decisions were decided, mandatory lifetime imprisonment for any post-conviction felonies while on lifetime post-release was the rule of law. That is no longer the case. Now it's discretionary with the parole board, and that is the current state of the law as far as I'm aware for quite some time. And that is why I reference in my brief that under the 2016 Hardy decision that Proctor does not provide a basis for relief as far as this particular appeal is concerned. So as far as that is concerned, the state respectfully submits that the district court did not err in denying the defendant's motion to find lifetime post-release supervision to constitute cruel and unusual punishment, and the state respectfully submits that should be affirmed. As far as the defendant's claim on issue 2 that it was error for the district court to deny the defendant's motion to release the defendant from mandatory registration as a sex offender, as a preliminary note, we do have a statute that specifically addresses alleged presumptions in criminal cases. That's KSA 4060-416, which mandates that any presumption or inference against the defendant in a criminal case created by statute or law is permissible, not irrebuttable. I believe.
But doesn't that statute really just deal with a jury situation where the jury can weigh the evidence?
I would need to research that issue further before I can address that. Previously, and in my brief, I referenced the Larson case, which the state does consider of a particular import in this case, where they were examining a DUI statute where an irrebuttable presumption was claimed, and they found that was not an irrebuttable presumption, at most a conclusive presumption, and rather a rule of law, and that is the state's position in this case. In 2023, the Kent Supreme Court even defined a presumption as a rule of law that requires a fact finder to draw certain conclusions from a proven fact or a set of facts in the absence of contrary evidence. However, KSA 224906 only requires the district court to apply the law mandated by the legislature rather than engage in additional fact finding per se. And for the state, and so the state's position is that the defense claim that a conviction under KSA 215510 creates a irrebuttable presumption without merit. The state respectfully submit is a rule of law, not a presumption. Insofar as the defendant's claim to have a liberty interest in his reputation, and that such an interest is recognized in the Kansas Bill of Rights, sections 1 and 18, there are limits to such interests, including when the person standing in the community, like the defendant in the current case, has been damaged. And there is case law out there to suggest that when that happens, that liberty interest can be infringed upon by the state without necessary due process. Of course, in R is of particular relevance in this case from the state's point of view, where they addressed a similar argument. First off, that although the defendant may focus on his interest in protecting his reputation, there's also the state's interest, which is the specific goal and non-punitive purpose of CORE. And they have found that CORE is non-punitive, that there is a state's interest in safeguarding public safety. In NR, and this is from 2021, so it is a relatively recent case, the Kansas Supreme Court found that the burdens of CORE's registration requirements are not so onerous to constitute punishment, and public dissemination of registration information does not rise to the level of public shaming, nor does it impose an affirmative disability or restraint and is not excessive and is rationally connected to a non-punitive purpose. So as far as the defendant's claims that he did not have the opportunity to present mitigating information, the state respectfully submits that in ours also instructive on this point, that even though the defendant may claim that he is somehow special and worthy of some kind of special treatment under the law, in our court specifically found that any mitigating circumstances in these situations are really irrelevant. As far as
What's your response to Mr. Miller's argument that NR only deals with procedural due process and he's raising a substantive due process claim?
the argument that a substantive due process claim is being made in this case, the state that would appear to be largely based off of the allegation that the mandatory registration as a sex offender statute creates an irrebuttable presumption, and the state's position is that it creates a rule of law, not a presumption, and therefore this particular issue should be analyzed strictly under a due process framework.
Right, but it's my understanding Mr. Miller is saying I'm not raising a procedural due process claim, I'm raising a substantive due process claim.
If indeed a presumption, an irrebuttable presumption exists in this case, then maybe a substantive due process claim would be present. But the state's position is that a presumption does not exist, that this is merely a rule of law, and therefore the substantive due process doctrine does not apply, and this is strictly a due process matter, procedural due process matter. And so again, this is a defendant who, at the district court level, when he signed the written plea deal, he acknowledged that he would be subject to lifetime post-release supervision and mandatory registration as a sex offender. And again, the case law is very clear that any claims of mitigation, he already had that right to do it while the case was still pending before the district court prior to being convicted, and certainly prior to being sentenced in this matter. So with all those, with all that being said, the state respectfully submits that the district court did not err in its decision to deny the defendant's motion to relieve the defendant from mandatory registration as a sex offender. And so for all these reasons, the state respectfully moves this court to affirm the district court's denial of both the defendant's motion to find lifetime post-release supervision to constitute cruel and unusual punishment as applied, and the defendant's motion to relieve the defendant from mandatory registration as a sex offender. And with that, I'll respectfully inquire if the court has any questions.
Thank you, counsel.
Thank you, Your Honors.
Mr. Miller, you have 4 minutes rebuttal.
Thank you, Your Honor. I did want to address the questions of the court about Mr. Rogers' knowledge, and it's on pages 2 to 3 of my brief record. I have a record site, volume 3, 21 to 22, and volume 7, 5 to 6. So what happened was he received an anonymous.
Could you repeat those record sites?
Oh,
please?
I'm sorry. Sure. Record volume 3, 21 through 22, and record volume 7, 5 through 6, pages 5 through 6.
Thank you very much.
Sure. So what happened is he received this link from an unknown person. It said CP on it. Well, we may know what probably that means, but Mr. Rogers told law enforcement during his interview he didn't know what it meant. So he clicked on the link, and he indicated that he did see thumbnails of the videos depicting underage children. But he said that he just saw the images, he didn't click on them. The ones that he viewed, he believed were possibly high school age or a little older individuals. He did have access to them for a period of time, but he deleted his app off his phone to Dropbox. As far as the
Can I ask a question about
Sure.
that? He deleted the app, but there's some indication from the record that the images still remain on his phone. I'm not tech savvy, so I don't know how that works.
No.
Is that accurate?
That is not, no. And in fact, there was a forensic examination of his phone, and there was no child CSAM on it.
It was in his Dropbox account.
It was in a
So
Dropbox account.
he could have still accessed it through a
Yes.
computer.
He could have.
He could have.
Or he could have downloaded the app.
The app again, it's still in Dropbox,
Yes.
so he just deleted his current avenue to get into his Dropbox.
Correct.
Okay.
Right. And on his phone, and this is on volume 4, pages 25 through 26, Detective Roberts found 10,456 pictures and 844 videos. This was on his phone. There was nothing indicating any CSAM. There's nothing in his internet search history indicating that he was out there searching for it. And I think these all are relevant to factor one of the Freeman analysis that looks to the facts of the case, that looks to the individual characteristics of Mr. Rogers. There were 12 counts, actually, and those were based upon 12 videos. But again, there was no indication, he viewed the thumbnail images, but he told law enforcement that I did not click on and look at them.
And what about the testimony, or it's my understanding the state says that when he's talking about getting a thrill or potentially selling the images, was that related to the legal pornography, or did it have any connection to the child pornography, those comments?
It's a little unclear, but he said he thought about it, but then he said, I'm not going to do it, and there's no evidence that he distributed it, sold it, or anything else.
When he thought about it, he thought about what? What is it?
About selling. But it's
child
unclear
pornography?
to me from the record whether he's talking about the child pornography specifically or just the pornography in general. And he did say he got a rush or a thrill out of it. But again, that was based on that it was illegal, and he knew it was illegal. Dr. Goodman never diagnosed him, or no one ever diagnosed him with pedophilia. So there's zero indications that he is attracted to underage children. I see that I'm out of time here. Mossman does talk about that Kansas is in the minority of states that have lifetime post-release supervision. And I would rely on that. I didn't do my own independent analysis, but that's what Mossman held. Mossman said that favored the defendant, but because factor one did not in Mossman, because it was actual contact sexual offense, they said it didn't apply. I think that distinguishes Mossman from this particular case. Again, if the court has any other questions for me.
No, thank you.
Thank you, counsel. Thank you both for your arguments. We will take the matter under advisement and issue an opinion as quickly as possible.